Yes. Mr. Westbury.
My Lord, I'm grateful. I circulated just before this morning a copy of an extract from a Natural England report, which was a reference in my skeleton argument.
Yes, I saw.
Not worked its way into the authorities bundle. I have copies of that if the court didn't get them in some other way.
I saw them. What I've done. Yes, here we are. The Stakeholder Working Group on Unrecorded Public Rights of Way. Report to Natural England.
Would it assist your Lordship or your Lord if I pass up copies? 2 copies perhaps for Lord Justice's Mails and Holgate.
It's 52 and pages 52 and 53. Is that all you're handing up?
Yes.
I've already got that.
Oh, I apologise. You know, I wouldn't want to burden the court with the entire thing. I mean, extremely briefly, because it really goes to the recognition of the issue of administrative clerical type errors and the need for those to be corrected in a more simple way than the full-blown definitive map modification order process, which is what was resorted to in this case. That's why we have, so there's only one way that the statute provides for corrections to definitive maps and statements, which is the definitive map modification order process. And it's been recognised that that's something that's a bit overburdensome where problems are of a sort of clerical type copying nature.
One man's clerical error is another man's footpath through their backyard.
Quite right.
It's as civil servants speak at its worst.
The provision...
Basic factual errors and clarifications. We spend half our time in this court worrying about what's a basic error and what's a factual error and what the differences are.
I think for present purposes, because this is proposed law that's not yet been brought into force, and you have, my Lord, in the bundle the provision which flowed from this section 53ZA. I don't propose to go to it now, but for present purposes, what it demonstrates is a clear recognition that errors, where they occur, are definitive and fall to be corrected through the definitive map modification process.
Yeah. I get that.
So I won't linger on that any longer. What I wanted to do is more or less 5.
Before you start your submissions, can I indicate we do need to rise? 2 members of the court have commitments at 4:30, so we need to rise at 4:15. We need to give Miss Bird the opportunity of a short reply.
Yeah, I'm conscious of that, and I'll aim. If there's points where I can speed up, I'll aim to read the bench and do that as well. Just so you know where I'm going, my Lord, I wanted to start with just clearing the decks a little bit, and I do want to go through the law as it applies to the particular maps in this case and look at the 1949 Act, the 1981 Act, so to clear up some points there. Then I wanted to set out an outline of the remaining submissions and our case. Then come to what submission 2 in my skeleton argument, the relevance of section 56 at all on review, which in my submission is a very clear point, which doesn't really help the appellant's arguments and attempt to bring it in. Then, fourthly, to address the question which was addressed by the judge, and in my submission is one of the reasons why Lord Justice Lewison saw some wider interest in this appeal, was the question of what map section 56, which albeit I say doesn't apply on review at all, but what map it does apply to. And then finally, to come to the inspector's approach with particular regard to the Trevelyan and Leicestershire cases, and set out in my submission that it was unimpeachable, at least it wasn't legally flawed. So, my Lord, starting with the statutory scheme and the various definitive maps in play, if your Lordships have got a copy of my skeleton argument, para 28, it's in the core bundle, page 46. I set out there and give references to the definitive mapping evidence and definitive statement evidence, I should say, that was before the inspector. And your Lordships will see that you start with a parish survey map, that's the first bullet. That's published in 1967. Under that, as a definitive map, and you get various stages: 4, survey map, then a draft map, then a provisional map, and then the definitive map. And it's a rather long, or potentially long process. Clearly, there's scope for, and we'll come to it in a minute, there's scope for appeal and representations. Then the second bullet, there was a review carried out. That was a review under Section 33 of the 1949 Act in 1970. Thirdly, then, there's the 1987 preparation of the map following various modifications. That's the one that's first on the inspector's understanding led to that clear shift, or certainly was a clear shift to the east. And then finally, a version was followed up in 2013 of that. Now, the inspector refers, my lord, to a 2020 revision of the definitive map. That's not one that was formally prepared. It's been put together. It's useful for people to know where the map sits, because in any given year there will be a number of modifications to the map. And those modifications may or may not be recorded on the formally prepared Section 57.3 map. So hopefully that will speed things up a bit. I just wanted to refer to the statutory provisions under which the maps were produced briskly. You've got those provisions, my lord, in the authorities bundle, page, right at the beginning, page 3. And the first point to note is section 27 on page 3 itself. This is the survey that is done, which created what's referred to as the parish map, or the parish survey map. Now, the reason you'll see in section 27 itself, the survey must be caused to take place, but it's done by the parish. If one looks just for a moment to section 28, that's because the surveying authorities, that's the County Council in its current incarnation, has to consult with the parishes, among others. And then in section 28.3, there'll be arrangements made for the provision of information by the parish council. So the starting point then, the definitive map process, not modification, the original definitive map process, are surveys carried out by the local parishioners. And just for a reference there is a useful comment on that point within Kent County Council's report on this case in the supplementary bundle page 7, para 25, which indicates bottom of that paragraph. I'll let your lordship turn it up.
Twenty
25. It's the second half of the paragraph from the words in practice.
supplementary bundle, page 25.
Page 7, I apologise.
Oh, sorry, my
No,
fault.
no,
my
not
fault.
at all.
Yep, parish map. Yep.
Where it says in practice, initial surveys are undertaken. That's what happened in this case, and indeed that was common. So that's our parish survey map, and you'll note from, if we go turn back to the statute, section 27, subsection 4, even at that early stage, there was an accompanying statement with the survey map. So the framework is set by the parish, and then that then informs the next stage, which is the draft map.
Yeah.
And we get to the draft map. Actually, you have to go, it's section 27.1 as well. Prepare a draft map at the top of page 4 of the authority bundle. That's the second stage. So survey map informs draft map. There's then, and I don't think it's necessary in this case to go through it, but there's then a series of provisions providing for modification, appeals and hearings. That's through in authorities bundle pages 5, 6, 7, until one gets to section 30 on Authorities Bundle page 8. That's the provisional map and statement, again with a statement of particulars. And then there's a further opportunity for review and challenge. And then one gets to section 32 on page 11 of the Authorities Bundle. And that you'll see the words about 5 lines down, after all those things have happened, the surveying authority shall prepare a definitive map and statement. I'm just pausing there. Those words, prepare a definitive map and statement, in my submission are the proper words that are used throughout the legislation to indicate how authorities do maps. They don't say copy, it doesn't say modify. You prepare a definitive map and statement. It's of some interest that word, the same word, prepare, is found in section 57.3. It's the same exercise, you're preparing a map. Then we've covered it, I think, with my learned friend, section 32.4. There's the original wording of the conclusivity provisions. It's not identical, but one finds that reflected in what's now section 56 of the 1981 Act. And then over the page, section 33 on page 12, that's the original wording of what was the review provisions. And it was under this arrangement, reviews had to happen at least quinquennially, so at least every 5 years, and that proved impossible as things turned out, but that was the demand of the statute. Periodical revision at least every 5 years. We don't need in this appeal to consider the Countryside Act 1968 at all, except perhaps in passing to note that it was the 1968 Countryside Act that was the trigger for the 1970 review that was done under the 1949 Act. So then one comes to the current arrangements within the Wildlife and Countryside Act 1981 that completely supersede the 1949 Act in terms of the mechanisms. And the first provision you have from there is the first of 3 key provisions, section 53 itself. And we've alighted on this, really the sort of critical point that my learned friend lights on in this case and did in the High Court. Definitive map and statement in relation to any area means subject to section 57.3, I apologise, and 57A1. So the latest revised map and statement, I'll come to it, but in my submission, fairly clear indication that the intention is that the most recently and up-to-date map prepared is the one that is the definitive map and statement, and it's singular. There's not a multiplicity of maps and statements. So one gets the definition of definitive map and statement in section 53.1. The rest of section 53 tells us what the review process is. So section 53.2 and following is about the continuous review, as it's called. And that is of some significance because, of course, that's the exercise that the inspector was doing, and it's the exercise that the council did prior. And logics will see how that's worded in subsection 2. Continuing duty, as soon as reasonably practicable, to keep the definitive map and statement up to date, if necessary, requisite in consequence of the occurrence of the events specified in subsection 3. So then one goes to subsection 3, and there's 3 events. The C, little c is the one that's relevant here. Little a is where there's an order, possibly in the planning context or something that changes the rights-of-way network, so that has to be added in. Little b relates to prescriptive periods of time, so where rights required by the public over land over time. And little c is where evidence is discovered that indicates, I summarise with the Roman 1 through 3, but indicates that something's wrong with the definitive map and statement and needs to be changed. And I'll draw attention, my lord, to the parenthesised words on page 18. the discovery by the authority of evidence which, and then it says, when considered with all other relevant evidence available to them, shows. All other relevant evidence, not just mapping evidence and not just a single map. The review process is as wide as it can be because the intention of the review is to ascertain what the definitive map should be, what the proper line is. So one has to, and the inspector was right to in my submission, look at everything.
Is that an indication that the conclusive effect provision doesn't apply during this process?
It's one of many. In my submission, that point is so well established that it's not really properly raised
Get it
before
from
this
the
court.
statute there.
But that's an indication of it, and it shows, in a way, if one were to put an anchor down, or however my learned friend puts it, onto one piece of evidence above others, you undermine what the review process really is about. I will of course come to Trevelyan and what that says and means later. So that's section 53.
Can I just ask you, just before we leave 53, 53(1)A, the latest revised map and statement, you say that's what, for our purposes?
That would be, and there may well be authorities where the most recent map is one that was prepared under section 33 of the 1949 Act. So under the 1949 Act, the most recent statement would be one prepared under section 33. So in this case, it would be the 1970 map. That was prepared under section 33.
Yeah.
The 1987 map postdates the 1981 Act. So that was prepared under section 57(3).
And in between, there was something else prepared. Was there?
But between those two, nothing formal. There would undoubtedly have been modification orders, but there's nothing formal. So
It goes from 1970 to 1987.
87, and then there's 2013, which is the most recent one.
That's what I wanted to be clear about. The 87 one was also under section 57(3?
Yes.
Yes.
So then, unless there was anything else on that, I mean, there is a cascade here, my lord, and you light on subsection 1A. That's the most recent, and then it says, or if there's nothing under that, you go back
Yeah.
to the original production, and there may be authorities in the country that still have the original map, nothing else. But
I was
and
just
then-
trying to translate it to our facts.
But on our facts, we don't need to go to subsections A through to C because of the crucial words subject to section 57(3) and 57(A)(1). So one has to make sense of this, look at section 57, which starts on page 25. And we're drawn to section 57(3) in particular, and as my Lord Justice Holgate noted already, it's a sort of deeming provision. What it effectively provides is that where a surveying authority considers it's expedient to prepare an updated copy of the map as modified, that's under any number of modification orders that may have been made in the meantime, they can do that. And that then shall be regarded for the purposes of the foregoing provisions of this part, pause there, obviously include section 56, and for the purposes of section 57(A)(1 as the definitive map and statement for that area. So it's as clear in my submission as day that there is a power for local authorities to prepare updated copies of definitive maps and statements. In this case, undoubtedly, although we'd have no direct evidence of it, no one's put in challenge that there would have been modifications within the Kent area that would have justified this exercise. And indeed, it makes an awful lot of sense to have this exercise done so that there is a copy of the definitive map and statement that people can understand and see as definitive. My learned friend...
And all they're empowered to do is to copy. So that excludes making a modification through section 57(3).
We've got some common ground on that, yeah.
Yes.
That's the intention. Now, of course, here's where errors can creep in because it might be that the map they're copying has, for example, thick lines that need some deciphering, or there's joins between the maps that need some working through. So there's the intention is that the map will reflect the previous version except where there's been modifications. That must be the intention. Otherwise, my lord, there'll be something improper going on because one would need modification orders to modify the map. There should not be modification orders done in this way.
Because if you exercise your power under section 57(3), am I right in understanding you don't need an order for that purpose?
That's right. So it's a formal process, as far as I understand. It's done by local authorities, but it's not done by order, and therefore it wouldn't be subject to all of the scrutiny. So your lordship will see, I don't think they're before the court, but subsection 2 refers to regulations. There are certain rules about what notation should be used in maps, and there's certain practices. Presumably, the intention is that experienced cartographers at surveying authorities would not generally be making mistakes. They are preparing a definitive map and statement, and they're doing their best to do it. Now, when mistakes happen, that's this case, I'll go back to it, they require modification. That doesn't mean that there was an initial modification that needs to be modified back. So I'll come to that briefly in sort of a submission on the effect, the conclusivity provisions, if I may, when I come to the point, I think, fourth points I was going to make.
So your submission is that a copy includes something which, as a result of error, is not a true copy.
If there's error in the preparation process, and that in my submission, preparation is a better word than copy, because it properly reflects the exercise that's being done, which is to pull together different modification orders, prepare something. It's not, I think, just it's meant to reflect the previous version, but there's also an element of skill that's needed to prepare the definitive map and statement. But that's a small point.
Yes, it doesn't say they may copy. You're saying they may prepare a copy.
So two further points on this. First, subsection 3A, that my learned friend draws attention to, and this, as was pointed out, was added. In my submission, if one reads it, one can see what it's doing. It's ensuring, for the avoidance of doubt, that if there's been modification orders since the preparation of an updated definitive map and statement, those modifications aren't somehow ignored. They fall to be read in, even if there's not been a prepared copy under section 57(3). And that makes some sense, because otherwise the modifications made to the map by order would depend upon the expediency decision of surveying authorities in preparing from time to time full reworkings of the map. And it would mean that the definitive nature, the conclusivity of modified rights of way would not take effect. So that's what that provision is doing. I think my learned friend, if I understood her submission in response to my Lord Justice Coulson's question, I think she was suggesting that the words any definitive map in subsection 3A fall to be given some meaning that imports possibly earlier versions of the definitive map. In my submission, that's mistaken. It's not a good reading of that provision. It's simply to refer to any definitive map, but the existing ones, not past ones. Second point on section 57 is...
Doesn't mean any definitive map within the area of a county council.
I think there's only one definitive
map within the country.
Within any surveying authority, there can only be one definitive map, even if that map may be spread across different places.
Well, except when you get to section 57A, which we haven't looked at. But section 53 is also some section that's dealing with consolidation, because some surveying authorities have inherited a number of definitive maps covering different areas of their county, and then they can consolidate the whole lot.
Yeah, that's right. I mean, I think local government reorganisation creates a need for the consolidation provision in section 57A, which I wasn't going to go to,
Yeah.
except to note it.
Well,
It's
you
in similar
get that
terms.
where local authority boundaries are being changed.
Yeah.
Yes.
So, and it happens relatively frequently that a surveying authority will find itself newly established and have a mix of different old maps.
Yeah.
Now, in those circumstances, it's clearly right that it can prepare a single definitive map rather than to rely upon sort of a cacophony of different maps. So the second point from section 57 itself is subsections 5 and 6. The court's already noticed subsection 5 that a copy will be kept, note singular. Subsection 6 is also significant because it makes plain that it's only the most recent copy that an authority needs to keep. And that's if your lordship look at the text under little a and b, that's set out in more or less in terms. Now, in reality, there are things such as local and national archives that keep copies of old maps, but the statutory regime is focused on the single most recent copy, and that's the one, in my submission, to which section 56 applies, only that one, and that's the one which, if we're attempting to modify the definitive map and statement, which we regularly do, that's the one we're trying to modify, not any other. So in this case, that's why 2013 version of the definitive map and statement was the one that was up for consideration. I don't think I need to go to section 56 particularly. So unless there were any questions on the statutory regime, that was that's sort of the first bit I wanted just to clear up in terms of the statutory regime, and I'll move to an overview of the Secretary of State submissions. So this is just by way of outline, and there's a couple of factual points that arose I want to just get out of the way as well. My lords, there's a single ground of appeal here, and it was recited by my learned friend in her oral submissions. It's that the judge was wrong to reject the appellant's case that the evidential presumption created by section 56 of the 1981 Act applied to the 1952 definitive map and statement, where on the appellant's case there had been no relevant modification. That's how it's put. It's anchored in, to use that word, and depends upon section 56 having relevant purchase on review. That, in my submission, is the first and most fundamental problem with the submission. In any event, if one steps outside of the review process, so if we're in the county court or there's any other dispute outside of review where the conclusivity provision applies under section 56(1), the judge in my submission, who did address the question because it was raised by my learned friend, was right to find that it applies to the most recent prepared copy of the definitive map and statement. The real issue in my submission here is not that. It's whether the inspector's consideration of the mapping evidence before her, and in particular, given the singular focus of the appellant of the 1952 definitive map and statement, was lawful, whether she had appropriate regard to it, and in her process of considering the review, came to a lawful conclusion. Now, within that, and I'll come to it, one does have to understand the Leicestershire case and the Trevelyan case, but the inspector did. And the inspector applied that line of authority and came to, in my submission, a lawful conclusion. I wanted, as I indicated a moment ago, to just mention a couple of evidential type points.
Just before you come to those, can I ask you this? I understand your submission about what you call the first problem was section 56 having a relevant purchase on the review process. I understand that. And then you said, but even if you step outside the review process, the judge was right to find that it applied to the most recent version of the map. presumably that second submission is a secondary submission, because if you're right on the first, you say on your case that's it.
That's right. And in my submission, it's actually an overture part of the judgment. It's para 31 of the judgment below addresses the point, but it didn't need to address the point because the judge found at para 28 that section 56 was irrelevant on review. He then goes on at para might have to ask you for a reference. I've got it, page 69. He then goes on at para 31 to address the argument that was raised by the appellant in the High Court about the application of section 56. Given his finding that section 28, that's necessarily obiter in my submission. And then as my Lord Justice Mells has indicated, one gets his actual conclusion on the facts at para 33 and why he rejects ground A. He's making that finding, and that does mean he's made a finding that stands on the record. If it's wrong, it may well be a good reason for the court to intervene or correct that, but it doesn't actually have a bearing on the outcome of his conclusions, given paras 28 and 33.
Thank you.
So briefly, some points just on the evidence. Firstly, this argument about the inspector's consideration of the 1952 definitive map, and I'm picking up points my learned friend made in the oral submissions, but she said that there was no explicit finding by the inspector that the 1952 map alignment was in error. In my submission, if one looks at para 33 of the order decision, taken together with para 35, so that's bundle 130 if that's where your copies are. So 33, so this is under, so the inspector's going through all the evidence and she gets to the definitive map, para 33, provisional and final definitive maps are the same, more or less. And she's indicating it shifts slightly further to the east so as to run through what were the then existing buildings 4, 5 and 6. I mean, there can be no clearer findings. Explicit, in my view. It's not, it's implicit, but it's a mistaken alignment. It's running through buildings. And then one at 35 gets the overarching, well, one of the two places where one finds this overarching conclusion that one had this incremental mistake which got worse over time. The inspectors plainly found, as far as the 1952 map is concerned, that it was in error, albeit it wasn't the full extent of the error, because that got worse. Second point on the evidence is, and just to underscore a point about...
But it's 2 points really, aren't there? One is that it's in error because it runs through buildings. And I suppose the other point is that what it does show is that it goes through what one might think of as yew tree cottage land rather than Victoria bungalow land.
Yeah, and my learned friend very fairly went to that early consultation version of the map that indicates that very plainly. Yeah. So, I mean, I think that's probably the reason why Kent County Council didn't try and take a particular point. They were like, well, it runs through their land, so we'll leave it at that and we'll rely on it. But that's the second point, my lord, I've made in passing already, which is when reading this decision letter, it's very important not just to look at one paragraph and how the inspector is considering the map. The inspector also had regard to ordnance survey mapping, and then she had regard to the statement, I'll come back to that in a moment, and she had regard to some testimonies before her, and draw attention in particular to para 39. Testimony from long-standing local residents that the finger post that was pointing through the appellant's property and the stile that was at the back of their property were on the old footpath. So we can't simply think that it's all sort of a one-trick game. where the map is the key thing. Indeed, and the inspector would have been quite wrong to do that. She had regard to other things too. On the definitive statement, your lordship's asked about that, and the inspector's conclusions on the definitive statement, I won't go through them. You can see what they are at paras 36 on page 130 and through, I think, to para 38 as consideration of the definitive statements and the draft statements. One point to underscore there, the definitive statement your lordships went to, that was, if you recall, in supplementary bundle page 35. The versions of the definitive statement the inspector's discussing in the passages that we just went to are on pages 28. That's the parish copy.
Sorry, I was just noting up something else. Give me that page reference again.
28
28 in the...
in the supplementary bundle, apologise. And I think that's crossed out because it's sort of been taken on board, and one can see the same text in slightly more legible form on page 30. That's the provision, that's the draft statement extract. Then it was simplified for the definitive statement. But you see it says commences at style. So the inspector was considering that as well. And the fact that there's a direct reference to the style, which on her findings was the style at Yew Tree Cottage. So it's not irrelevant. And I don't think says, oh, don't worry about that. Because that, of course, supports her very myopic, in my submission, focus on the 1952 map, trying to find legal error, which there isn't any. But in fact, one has to stand back when looking at the lawfulness of this decision overall and consider the other evidence the inspector had regard to as well. And I think that's...
So what you've been showing us is a statement attached to the parish survey, which doesn't make it in that level of detail into the definitive statement, but nevertheless you say is evidence. Yeah.
It's evidence, and I think this stuff tends to be kept in the archives, but it's relatively normal to go back and try and understand the process to if there's evidence of a mistake, to try to get to the right conclusion, and that is evidence that the inspector properly relied upon in my submission. So I'll then move on to section 56 and its relevance, so the third heading, if that's acceptable. I've covered this a little bit already. I do think it's important to emphasise this. Section 56 did not feature in any material way in the appellant's, then applicant's case before the surveying authority or the inspector, or in its written submissions below. It was a point that was raised in oral submissions, and one can see that in the reference, I think. I forget exactly how the learned judge put it. The submissions were reframed, or I'll get the reference. I apologise. Yeah, so it's page 68 of the core bundle, para 24, little Roman 1. The learned judge, Miss Bird, refined ground A. That's what it means. The only references one has to section 56 in the written submissions in the High Court is just a reciting of the provision, no reference to it having any meaningful purchase. And that was right. It was a reason why section 56 was not argued before the inspector. But it does, in my submission, make it a little bit unfair to heavily criticise the High Court judge for particular wording that he may have used when addressing this point that was only raised orally before him. And in my submission, the appellant's case was unclear and remains unclear. As I understand the appellant's case on this point before this court, it's been reformulated. a halfway house. It's not that section 56 does not apply on review, or that it does apply on review fully. It's that it applies in a limited way, or it applies subject to some procedural inquiry. So section 56(1) should apply, the appellant says, unless there's evidence that proper procedures are not being followed. But in my submission, that is an attempt to reintroduce section 56 on review, which is quite improper, has no founding in the authorities, and would have the effect, the undesirable effect, of inhibiting the review process and therefore going against accuracy and certainty, which is what effectively drove the authorities when this tension between section 53 and section 56 came up in the case law. I don't want to go through the case law on this to a great degree, because in my submission it's extremely clear, Court of Appeal authority, that section 56 does not have any application on review. Any application, so not some qualified application, as the appellant now argues. The key authority for that, my lord, is Sims and Burrows, or Burrows and Sims. In that case, as I think your lordship has seen,
You don't want to go to it, I understand that. Could you just give us the reference and page reference of the authorities?
so the key references are so Lord Justice Purchase, and it's Authorities Bundle 88, between 385 and 386, if one looks for those little indications of page numbers. Glidewell, Lord Justice, AB, Authorities Bundle, page 92, between 391 and 392. And for the avoidance of doubt, Lord Justice Russell as well. Next page, page 93 of the Authorities Bundle at 392. Page 93.
Thank you.
But if it helps, in my submission, the clearest encapsulation is actually Lord Justice Glidewell's, just the single clearest encapsulation, but it's clearly a common view across the court. The case that was before the judge was Trevelyan, and that's the one that he quotes. Again, just reference only, 2 paragraphs, para 12, Authorities Bundle, page 99, and para 28, Authorities Bundle, page 102. There are others, High Court authority for it, but you don't need it. In my submission, there's an obvious logic to it as well. Were section 56 to have any application on review, it would preclude or at least distort the review process, and that was what the deputy judge in this case recognised at the end of para 28. Briefly, last point on this topic. My own friend resorts to referring to passages in isolation from Kent County Council's submissions in their report and in their statement of case to try to find some support for this argument. In my submission, insofar as Kent County Council may have suggested by using the word conclusive that section 56 may have any application on the review, they were mistaken. So that was an error. But I think, being fair to the county council, they probably didn't mean that, because the references my friend relies upon follow a discussion not of section 56, but of the Trevelyan case. The key thing here, and this is another case, but I'll touch on it briefly. The key thing to recall is what was said in Norfolk, where the issue came up. So Norfolk was one of the cases, one of 2, where there was a discrepancy between the map and the statement. And in Norfolk, Mr. Justice Pitchford, you were taken to the previous paragraph, but it's Authorities Bundle 161. Page 161 of the Authorities Bundle, para 63. Is it's important to distinguish between the 2 forms of presumption. They're really quite different. goes on in the text underneath the quote from Burroughs and Sims, to say in the clearest terms, the only presumption capable of applying at the review stage is thus the evidential presumption identified by the court in the Appellants case. In Norfolk, that mattered because the argument, and you get all of this from the head note, if the court turns back to 145, the argument was, well, the presumption in section 56 applies to the map as to the right of way and to the statement as to the particulars. So the map would take priority applying the section 56 conclusivity presumption. Applying section 56, map takes precedence, but the court held that the inspector had erred because she had treated on review the map as primary. So it supports what I say, which is section 56 has no application whatsoever on review, and to try and apply it even in the more subtle way that it was applied in the Norfolk County Council case would lead the decision maker into error, and it did in that case. So that's everything on the sort of the relevance of section 56. I wanted to touch on the para 31 question from the High Court judgment below, which is the question that was answered by the judge with the answer that the most recent version of the definitive map and statement is the one to which the presumptions, I should keep calling it presumption, I should not do that really, the conclusivity provision within section 56 applies. And if I can just briefly set out submissions on that, you have this in my skeleton argument under, I think it's submission, well, I made a note of it for convenience and then I can't find it, but it's I think it's my second submission, submission 2 in my skeleton argument. I've said that enough. I now wonder if it's submission 1. Give me one moment to find my bearings.
We're still under the heading of section 56.
We moved from the heading of the relevance of section 56 to a different heading, the application of section 56, if one steps away from review.
Yep.
And it is my submission 1, paragraph 34 and following the skeleton argument.
Yep.
So this is a question the court may want to engage with. It was engaged with by the judge below. It doesn't make a difference in my submission to the outcome of the appeal. The question, if it arises, to what definitive map and statement does the conclusivity provision in section 56.1 apply, is answered the most recent version of the definitive map and statement prepared under the statutory provisions. I've covered this a little bit when looking at the provisions themselves, when we looked at section 53 and 57, subsection 3. So I'll just make 3 supplementary points. First, there can only be one definitive map and statement. Otherwise, there's no certainty, and it would defeat the purpose of section 56.1, the conclusivity provision, were one to have questions over multiple definitive maps and statements. That being so, it's logical that it's the most recent and, at least presumptively, the most accurate one. I'll remind the court of the basic purpose of the statute as set out in Sims and Burroughs. For your reference, it's on AB Authorities Bundle, page 72. And your lordships might recall the language to avoid tiresome and expensive litigation between individuals over disputed rights of way. My submission, the appellant's arguments in this case, are to try and encourage such arguments. Second point is to look at the statutory language, and we've done that, so I don't think I want to labour that. But if one looks at the statutory language in my submission, it's very clear that it's a single definitive map and statement, and see subject to section 57.3 the statute directs you in that cascade way to the most recent. So if there wasn't a section 57.3 map, one might then go to the earlier revised one or the previous revised one, but it's the most recent one that should apply, and that's clear from the statutory framework in my submission. Third, and it must be accepted that if mistakes are made in the preparation of section 57.3 maps, that can cause problems. That appears to have happened in this case, or at least to have been exacerbated in this case in 1987. But as the Master of the Rolls, Lord Denning, put it in the Morgan case, the statute will have it so. And the reference for that in the bundle, my lords, is first case in the authorities bundle, page 64. If you can find it, the case is the first case, so it starts after page 61. The number is quite hard to see because it's all blacked out. Must have at least one in there. So in the report, it's page 458. Now this case was from the 1960s, so it goes back. It doesn't apply to the 1981 Act, but it was about mistakes, and the language I'm drawing the court's attention to is the red line passage on page 458. The Act must prevail, it's conclusive. You'll see 4 lines down, the Act will have it so. Then the next paragraph down at the end, there it is, the statute will have it so. There is a price to certainty, and it might mean that mistakes happen, and then this is where one comes back to the attempts to recognise this and provide other ways of dealing with it. But the mistakes need to be corrected through the further continuing review. But in short, if a mistake creeps in the section 57.3 process, that is definitive. Now, I wouldn't rule out, because I don't think there's any exclusion here, the potential for judicial review or if there was some outrageous error. But one has to also bear in mind there's an alternative remedy of seeking to modify the map, and that the statute would expect the preparation, and this is why I drew attention to those words, of definitive maps and statements by surveying authorities to be done conscientiously. There are, as I've indicated, regulations which apply, the 1993 definitive map regulations. And for errors to be relatively uncommon. Where they do occur, it might be for entirely understandable reasons, such as thick lines on old maps. Perhaps some things that are difficult to interpret and carry across, that don't in themselves justify a modification, at least not at that time. And that may be what happened in this case. Your lordships will have seen the mapping evidence is hardly particularly clear. So I then, and I've touched on it already, but insofar as the statutory scheme goes, the final point here is that this has been recognised by Parliament, and insofar as it is seen fit to bring into effect section 53ZA that you've got in the authorities bundle, and that would require further regulations to be made, so there would be some protections, but that provides in short that where there's an obvious error and an obvious correction to that error, whether that's this case or not I don't need to touch on, but where there is that sort of situation, that that can be done on a more efficient basis than the I see your lordship looking for the provision, so it's at page 59. So Parliament has recognised there might be a good reason to have an expedited and simpler process to correct, as it says at the top of section 53(7)(a), modifications arising from administrative errors.
So this isn't yet in force?
Not yet in force. So it's, I mean, it's fairly long in the tooth because it was introduced by the Deregulation Act 2015 with a number of other provisions, but this one, along with many of the others, I think, has not yet been brought into force. So the last
And it would only apply if both the error and the modification are obvious. So
Yeah.
even if it were in force, we'd probably have an argument about whether it's obvious or not.
I'm not suggesting that it would apply on the facts of this case necessarily. It would depend upon.
The procedure is there.
I'll repeat what I said at the outset of this afternoon.
It was noted, and I did think about the word obvious and how one man's obvious is another man's utterly obscure. That brings me then on to the last point, but perhaps really the nub of the actual legal challenge here, which is the inspector's treatment of the 1952 map. I've already made a number of submissions upon this. Within my skeleton argument, this is submission 3. So I addressed this at paras 44 and following.
Yeah.
And the starting point here is to go to the decision letter itself and to see how the inspector directed herself. And it's in the background section, page 127 of the decision letter. You'll see she sets out the case first, and then she comes to para 11, referring to Mr. Grant, who is the barrister for Kent County Council, and Mr. May, who is a solicitor for the appellant. Both relied upon the words of Mr. Justice Collins in another similar case, Leicestershire, and then she quotes the relevant bit from Leicestershire. And then she says over the page at para 12, that's the approach I propose to adopt here. And in short, the approach she proposes to adopt is to look at all the evidence and to see whether she can come to a positive conclusion as to the correct alignment. Having come to that positive conclusion, that displaces any presumption as to an alternative alignment. It's as simple as that. One can see those conclusions set out at paras 46 and 47. So 46, the positive evidence to support the amended line. Then those words that my friend mentioned, but in my submission they're very much capable of understanding. Most likely explanation, obviously the most likely explanation of the alignment of the footpath was the public use route A to B to X and then X to C, so i.e. the order line. And then at 47, absence of any evidence to support the existing line, which she has concluded positively again was mistaken. So it's in the end just 4 paragraphs of the decision letter, but it wraps up in my submission with all the consideration of the evidence in between, an obviously lawful approach. And insofar as it said that the inspector needed to attach some special status trumping other evidence to the 1952 map, that's misconceived. And I think on the way it was put by my learned friend, her argument depends upon section 56 having some purchase on review, which it doesn't. That leaves the detail of the Trevelyan and Leicestershire cases. So I did want to just briefly turn to those. They're really the 2 authorities that go to, if one can call it, the sort of in-review approach to the existing definitive map and statement. So what effect should it have, if any, when one's involved in a review? One, the Trevelyan case, has the weight of Court of Appeal authority. The other has a significance of being peculiarly proximate to the facts in this case. That's the Leicestershire case. But if we start with Trevelyan, that's authorities bundle, page 94 is where it begins. And I think we can just go straight to the oft-quoted para 38 on page 104. I'll go to this and then to Leicestershire and then make submissions on both, if I may. The court's read this. I'll just ask your lordships just to remind yourselves of what it says at para 38. And then one gets the Leicestershire case, which starts on page 108 of the bundle. A couple of preliminary marks about Leicestershire. It's an extempore judgment following a slightly unconventionally rolled up hearing by Mr. Justice Collins, with the agreement of all the parties before it, I should emphasise. There's no reference in the judgment to Trevelyan, but in my submission, the conclusion of Mr. Justice Collins is on all fours with Trevelyan, showing that Trevelyan is common sense, apart from anything else. On the facts, if your lordships have page 109 and para 4, you'll see, just like this case, at least on the alternative argument, the opposable argument, because they ran their cul-de-sac point too. It was neighbouring houses, and the question being which one of the houses does the house's grounds does the footpath run through, Manor Cottage and Glebe Cottage. So it was strikingly similar to this case. Having set out the background, you'll see on the red line section on page 112 that the inspector who was considering that case was particularly impressed by some evidence from the chairman of the local parish meeting, what he would have marked. So, pausing there, insofar as our inspector gave weight to the parish map, I'd be consistent with that, but it's a side point. Because of the evidence there, the particular impression from the parish councillor, the inspector was not satisfied that there was evidence to show that the line was wrong. Wasn't satisfied, so he did not confirm the order, and that's why it was then challenged by the council who've made the order. On the test to be applied, one goes to page 114, paras 28 through 29.
Yeah. I'll just read those.
Yeah. So, my lords, in my submission, both Trevelyan and Leicestershire are effectively common sense practical guidance as to the weight that should be given to mapping evidence. And although Trevelyan was not cited in the Leicestershire case, or doesn't appear to have been cited, para 29 of Leicestershire is on all fours with Trevelyan. And I say that because what Mr. Justice Collins is contemplating is a finding on the balance of probabilities that an alternative is right, And that is, to use the language of Trevelyan, evidence of some substance that would overcome any presumption. In my submission, there's some obvious force in the 1952 map being evidence. It was evidence that the inspector had to consider. It was evidence of something. But once the inspector had regard to it, considered its alignment to be problematic, considered it to, in the context of the parish map, and of course the further mistake happened, and came to a positive conclusion that an alternative route to that shown on the 1952 map was right, any presumption would fall away. Now clearly I don't think there's any dispute between the parties that the presumption in favour of the 2013 version of the map fell away almost immediately. I mean, on Kent County Council's case, it falls away because it's accepted it's in error. But the oddity of this case is that, of course, it was the appellant who was arguing before the inspector that it was right. The 2013 version was right. But the appellant can shift their case if they like. That's not what they're arguing now. I make the point in my skeleton
That
argument
was their
about...
alternative case, wasn't it? Their first case was the cul-de-sac.
Yeah.
Second case was somewhere else, Victoria Butler.
I make the point in my skeleton argument that the case they've ran in the High Court and indeed in this court is not entirely consistent with the points they raised below. But, I think I don't need that pleading point to win in my submission, because in my submission the points that they seek to raise here, one, that they were not raised before the inspector, but two, in my submission they're meritless and don't really address the inspector's fundamental reasoning. Those were my submissions, unless my lord, your lordships had any questions.
Let me just... No, yep, thank you very much, Mr. Richmond. Yes, Ms. Bird, any reply?
Yes, my lord, briefly addressing my learned friend's points in reverse order.
Yeah.
So, dealing first with what I understand to be the fundamental submission that's made, which is that the 1952 map was evidence of something. And if it was evidence of something, it fell to be considered in accordance with Section 32 of the Highways Act 1980 in this case. And if your lordships go to paragraphs 36 and 37 of Trevelyan at the Authorities Bundle, page 104, it can be seen that the parties in that case agreed, this is paragraph 37, that the provision is applicable by analogy to the weight to be attached to the definitive map in the context of the inspector's task of considering whether, having regard to all the available evidence, he was satisfied that the right-of-way depicted as a bridle way did not exist. But as I've already said, and I don't wish to trespass on your patience by repeating, the inspector's task in Trevelyan, as in Leicestershire, was the task of considering whether the map under review was correct. It wasn't the task of considering whether the original definitive map and statement was correct. difficulty with the section 32 approach that my learned friend contends is the right one is that it runs contrary to the principle that there is a distinction between a definitive map and the other evidence in the jigsaw puzzle that the decision maker has to consider. For your notes, in the court below, the Secretary of State and a friend argued at footnote 7, which is at Core Bundle page 83, that piecing together map evidence is an entirely appropriate approach in cases about historic evidence for rights of way. See Fortune and Wiltshire at 78, referring to pieces of a jigsaw puzzle. But if one looks at that paragraph in Fortune and Wiltshire, on which I assume my learned friend still relies, so page 241 of the bundle, the penultimate sentence on that page this is the judgment of Lord Justice Lewison. The argument was essentially about whether the Finance Act map was treated correctly. And Lord Justice Lewison says, but the judge did not treat the Finance Act map as definitive. It was simply one piece of the jigsaw puzzle. So, my lord, in my submission, that is another indication that the Section 32 Highways Act approach is not the right approach to take, because it places the original definitive map, which went through the whole of the 1949 Act process, in the same evidential category as every other map or document to which the inspector may give whatever weight they consider fit. My learned friend submitted that there is no special status to the 1952 definitive map. It depends on section 56 having some purchase on review, which it doesn't. And again, at the risk of repeating myself, the appellant accepts that section 56 is not conclusive on review. But it's not correct to say, as I understand my learned friend to contend, that section 56 doesn't apply to review at all.
So if it's not conclusive on review, how does section 56 apply?
That's where the initial presumption in Trevelyan comes in.
So it amounts to that?
Yes.
Okay, thank you.
In relation to my learned friend's submissions on the inspector's decision letter, regarding the inspector's conclusions at paragraphs 46 and 47 of her letter, my learned friend pointed to the inspector's identification of the most likely explanation of the order line That's what the inspector was looking for. She was looking for an explanation of the order line. Now that's approaching the problem backwards. It's assuming that the order line, the modification line, is correct, and looking for evidence to explain it. The appellant's submission has been consistent that that was the incorrect approach. My Lord Justice Mayall's picked up on the point in relation to the new section 53 ZA, which may or may not come into force, and it applies only in the case of obvious errors and obvious corrections. My learned friend also relies, as I understand it, on an explanatory note to the Deregulation Act, which is at page 61 of the authorities bundle, paragraph 608 on that page. Last line of that paragraph. This, i.e. the new provision when it comes into force, will remove the burden on an authority which must presently follow lengthy procedures designed for potentially contentious situations.
Sorry, where are you reading from?
Paragraph 608, my lord, of that page 61 of the authorities bundle. It's the third paragraph.
Thank you.
Last line of that paragraph. My learned friend made a submission to the effect that the statute will have it so that mistakes become part of the definitive map. We don't disagree with that, my lord. They do become part of it, and they are definitive until review, or they are conclusive in accordance with section 56(1) until review. And it's at the point of review that that changes. And that's absolutely clear from paragraph 63 of Norfolk, to which my learned friend has called. Reference to the two forms of presumption. As to the point that was made that the appellants didn't raise this issue about section 56(1) at the hearing, the reasons for that are set out at paragraph 52 of the appeal skeleton. I beg your pardon, paragraph 45 of the appeal skeleton on page 27. As I've said there, the first respondent did not submit, either in its acknowledgement of service of the claim or in the skeleton argument for the hearing, that the appellants were wrong to contend, as they did in grounds A and B, that the section 56(1) evidential presumption applied to the 1952 definitive map and statement. The only criticism of that submission is at paragraph 29 of the first respondent skeleton in the court below. And no suggestion was made there that the presumption applies to a later copy. And I do point to the council's approach, which I submit was correct, on conclusivity of evidence, in combination.
Sorry, I'm not following this. We're dealing with the point that was raised by Mr. Westway, that the point about 56.1 wasn't raised by you in the court below.
Yes.
And your answer is?
My answer is, in short, my lord, we didn't expect it to come as a point.
That was your
in
appeal.
issue. Yes, my lord, but that was the point. We argued that section 56.1 ought to be taken into account.
But I think it was rather more nuanced than that. It was the specific points that you made this morning about 56.1 and your criticisms of the judge. And it was said, well, that's all a bit unfair because that wasn't raised until the oral hearing.
Well, if that's your lordship's understanding, then so be it. But it wasn't my understanding. My understanding was that the complaint that was made was that these arguments weren't made below about the conclusive weight to be attached to the 1952 map and statement. And the reason they weren't made is that, to be entirely candid, it wasn't anticipated as an issue because there was no point made in the Secretary of State's acknowledgement of service or their skeleton argument.
Yeah, well, that goes back to the point, who has the carriage of the appeal? Anyway, there it is.
There it is, my lord. More importantly, on the inspector's decision letter, my learned friend argues that the inspector clearly found the parish map to be the right one. That's the one that shows the right of way. And if one looks at paragraph 35 of the decision letter, the inspector says this about the definitive records, which include the parish map. She says, tracing these maps through in sequence illustrates the claim by Kent County Council that the historical line of this path does not match that shown on the current definitive map, but has been altered subtly eastwards on each redraft, but with no deliberate intention in the form of a legal order to do so. So if, as my learned friend contends, the inspector thought that the parish map was right, she must have thought also that there was nothing in sections 27, it's 28 and 29 of the National Parks and Access to the Countryside Act 1949 that allowed for an order to be made changing the alignment on the parish map before the provisional map, before the draft map was prepared. I beg your pardon. And the draft map was prepared, and then eventually the definitive map. But of course, the 1949 Act did provide for that. So in paragraph 29 of the 1949 Act on page 5 of the authorities bundle, On completing the preparation of the draft map and statement, the authority shall notify the minister and shall cause notice of the preparation thereof, and so on, of places where copies of the draft map may be inspected at all reasonable hours, etc., and representations or objections with respect to that map may be made to the authority. Under subsection 2, the owner of the land may make representations. Subsection 3, if any representation or objection is duly made, as to anything contained in or omitted from the draft map and statement, the authority, after considering that representation and affording to the person by whom it's made an opportunity of being heard, shall determine what, if any, modification of the particulars contained in the draft map and statement appears to be requisite. So quite plainly, the parish map which the inspector thought was right on my learned friend's case had this stage of the statutory process to go through. Which included appeal to the minister under section 29(5) on page 7 of the authorities bundle. Before the preparation of the map in the next stage, which was the provisional map and statement. And that went through yet another process before it became definitive.
Are you saying, in short, there could have been a modification under the legislation?
Yes, my lord.
But the inspector didn't think that was necessary. But where does that take us?
Well, because, my lord, the inspector makes a finding that there was no deliberate intention in the form of a legal order to move the line, but she doesn't take into account the fact that there was every opportunity
Well,
for that
what
to
I'm really
occur.
asking is, how does that affect the application of the 1981 Act?
Well, it doesn't directly, my lord.
Anything else?
Yes. Your lordship will bear with me a moment. The first point I think my learned friend made, or one of the earlier points, was that the authority is not obliged to keep a copy of every definitive map and statement, which is obviously quite an important point. There's a difference between section 57.5 and section 57.5. The surveying authority shall keep a copy of map and statement and all the orders. 6, to which my learned friend draws attention, is that they shall not be required to keep available for inspection more than one copy. So that's plainly different. It's not a question that once the map has been copied, the original map and the earlier orders can simply be discarded. They must be kept for reference, and they invariably are, as they were in this case. And finally, one of the friends' overarching point that section 56 does not apply on review at all is misconceived. It does, because it is because of the existence of section 56 that the initial presumption in rebellion applies on review. So plainly, section 56(1) does have purchase because it triggers the application of the original presumption, the initial presumption, I beg your pardon. But in the event of a map that is not under review, the section 56 conclusiveness still applies. Those are my submissions, my lord, unless I can
Thank you
assist
very
any further.
Right. Thank you both very much. And to those sitting behind you, we will perhaps unsurprisingly reserve our judgments in this case. You will get a draft of those judgments in the usual way. That's an opportunity for you to comment on the grammar and the typos. It's not an opportunity to re-argue the case. When you get that draft, please remember it is confidential. Please remember that it is a contempt of court for the draft to be circulated to anybody other than on the approved list of those who are receiving a copy of it. Once you've got the draft, at the same time as commenting on any typos, if between you could draw up an agreed order that takes into account what the judgments say, then that would be very helpful. To the extent that you can't agree anything, we will resolve any differences in writing, so we would need to see very, very short submissions on the points on which you disagree, if there are any, and we will then resolve those, let you know what the answers are, and then you can draw up the final version of the order. Obviously, when the judgment is handed down, there's no need for any attendance. That will all be electronic. All right, thank you very much.
Court rise if able.